And so one of the hottest rulings over the past year involves the Supreme Court's decision involving Harvard and Affirmative Act. And you may question, well, why are we talking about that here? That's not a labor and employment case. Well, first, let's back up a little bit. The Supreme Court there held that considering race as a plus factor in college admissions violates the Equal Protection Clause with respect to public institutions and Title VI of the Civil Rights Act with respect to institutions that receive state or federal financial assistance. That has nothing to do with private employers. And you're right, this ruling does not directly apply to private employers. That said, I do think that it is a harbinger of what is potentially likely to come with respect to where individuals will likely bring lawsuits, especially in like the reverse discrimination setting down the line. And so unlike in higher education, under Title VII of the Civil Rights Act, affirmative action with respect to race or gender preferences has never been permissible in the employment context. Many of you probably already knew that. I know we discussed earlier, one of the very limited exceptions to that is casting in the entertainment industry. Another would be bona fide occupational qualifications. So for instance, ensuring that there are men and women who are security guards at TSA so that women feel comfortable being patted down by women and men feel comfortable being patted down by men, et cetera. But otherwise, you cannot use race, or gender, or any other protected category when making employment decisions. And so, okay, well then why are we talking about this subject matter? Well, because I think that these issues are going to be increasing in terms of the level of scrutiny going forward. And so let's walk through sort of the line by line things that could be the impacts that this Harvard ruling has on employers. So first, individual employment decisions. Every day, making hiring decisions, promotions, terminations, I would anticipate that this will have little, if any, impact with respect to that. As I said, you can incorporate your decision, the fact that someone is the member of a certain protected category, that cannot be factored into their decision, but for the very narrow circumstances they already shared. So very unlikely that there's going to be any impact there. Here's where things get a little bit interesting. So if you have say you want to have a diversity fellowship, that you want to increase representation because you would like to have more African Americans in your workplace, and you created a special sponsorship or a mentorship program to specifically highlight underrepresented groups. That is likely going to be the next area that litigants are likely going to try to combat. Now, why? Well, as you know, the Supreme Court likes to make things in very incremental changes. It took a very incremental approach towards finally the death knell of affirmative action and college admissions. And this is likely the next legal frontier, so to speak, of where they're headed. And so, in these circumstances, you're expressly leaving a certain position available for a diverse employee, part of the anti-woke movement, with the rise of reverse discrimination lawsuits. There are going to be individuals who are white who say, well, that's not fair. That's a spot that should be going to me. And there are already lawsuits cropping up on this exact issue. I'm not saying you should no longer offer those fellowships or sponsorships. I'm just highlighting to you the fact that this is something that's on the rise and something to be wary of going forward. Affinity groups. So, these are usually groups that represent certain underrepresented groups. Like, I know I'm a gay attorney. We have a wonderful group at MSK called MSK Out. There are other affinity groups. And, one thing to consider there, if there's certain money that is being earmarked specifically for that affinity group based on their category, some people may take issue with that. And so one thing to consider here is considering opening membership or participation to all employees. We love allies, so it seems unproblematic to me to encourage allies to be part of these affinity groups, but that is something likely down the line. There hasn't been any cases striking down any sort of affinity group participation yet, but it's certainly something I would consider. Diversity requirements for interview slates. So this would be something like the Rooney Rule. So if you're not familiar, the Rooney Rule, this is something that was implemented at the NFL. This is probably the extent of my NFL knowledge, actually. What it says is individuals who come from unrepresented groups need to be included in the recruitment and decision-making with respect to head coaches and like senior football officials. Let's go with that. Yeah. And there, it's not, I do not anticipate that there'll be any impact there. You're not making an employment decision. You're just including certain people as part of the pool to encourage having a more diverse pool, but doesn't mean that you're necessarily going to be choosing those individuals. The employment decision itself is separate. And so I do not anticipate that there would be impact, at least for now, with respect to diversity requirements for interview slates. And then the last being statements setting diversity goals. So this would be my production company or my company is committed to increasing diversity, or we respect people from all walks of life, race, ethnicity, gender, sexual orientation, et cetera. Unlikely at this juncture that these are not facially unlawful. However, there was one case in this past year where a white individual said that there was a statement setting a diversity goal that they would like to increase their minority representation at like the partnership level, like at a VP level or above, at 40% or higher. And in that circumstance, the court allowed that person to survive a motion to dismiss and proceed forward with the case on the basis that that statement in and of itself suggested that he could have been discriminated against for not receiving a certain promotion. And so if you have certain statements setting diversity goals, we're more than happy to take a look at them and see if we think that there are any issues that deal with compliance on them, but unlikely to have any impacts there. So just very basic level here. As I mentioned, race, gender shouldn't be used as a plus factor to improve workplace diversity. It is appropriate also when there is a written affirmative action plan that meets very specific EEOC guidelines. Just head note that. Beyond the sourcing, which I mentioned, like the Rooney Rule and recruiting, race shouldn't be a factor, or sex protected categories when deciding who makes it, to the next level on a selection process. And that diversity initiatives here shouldn't be a zero-sum game. They should be designed to expand opportunities for underrepresented groups. That's obviously something very important, but also not negatively impacting those in the majority. And I'll just say, we have dealt with a number of reverse discrimination cases. I'm dealing with one right now where these exact issues are coming up. And so it's, this is on the rise and something to be aware of in the coming years.